Welcome to Miranda Warnings Roundtable, discussing legal issues and current events. I'm joined on the roundtable by Liz Benjamin and Professor Vin Bonventre. Liz is the managing director at Marathon Strategies, a public relations and communications firm, and former host of Capital Tonight, a political and policy show focusing on New York State politics. And Professor Vin Bonventre, Distinguished Professor of Law at Albany Law School and publisher of the New York Court Watcher, devoted to commenting on the U.S. Supreme Court and the New York State Court of Appeals. This week on Miranda Warnings Roundtable, we're going to discuss the U.S. Supreme Court preview. We've got Vin and Liz, as always. Welcome both.
Great to be here.
Great to have you. So we've talked a lot about the last Supreme Court term, and I guess I want to start this off with both of you. Do you think we're going to continue to see the break with precedent that we saw last term, or do you think we'll get back to something closer to normal in this court?
There is no normal with this court.
I said closer to normal.
No, there's
we're going
normal,
in the other direction.
Hate that. So cliched, but this was a break from the approach to measured movement by the Chief Justice, and the conservatives, are having their way. Don't think they have any intention of going backwards. I think we'll see more of the same, and they'll be stretching the envelope further. I can't imagine why they would all of a sudden have a change of heart.
Yeah, I think certainly church and state cases and affirmative action cases, we're going to see some overruling, whether they call it overruling or not. We're going to see that.
Yeah. I do want to say, though, I don't think it's helpful for Biden to be like, oh, this court. I mean, he's adopted the same rhetoric that you used to hear from people who didn't like the liberal court. Oh, this court is, making precedent. It's advocate and not justices. There's no jurisprudence, blah, blah, whatever. I mean, that's not helpful. If you really have a problem, change the Democrats have been talking about it forever. I'm not endorsing it, but change the makeup, like to add more seats, like if you have a real problem.
But don't you think, perhaps it was clumsy the way he articulated it, but it is different that the court is just voting repeatedly. The Republicans on one side, the Democrats on the other. That is kind of different. That's different than just saying, well, I don't like this particular decision. I don't like that particular decision. The fact of the matter is the justices on this court, they're just not behaving like we expect judges to behave. They're behaving like partisan politicians.
Which is exactly what we expected from these particular justices.
From them, sure. Well, when you have presidents who repeatedly are pandering to the base of their party, and so you have the Democratic presidents putting just liberal ideologues on the court. You have Republican presidents putting conservative ideologues. This is what you get.
I just think it sounds a little like sour grapes. That's all. And also it's a little bit like whining, because there's nothing that you can do to change the current situation except potentially increase the number of seats on the court. But if what Vin just said holds true, and we're continuing in the same pattern of putting ideologues on the court, then that's not actually going to help anything. Then you just have more liberal ideologues voting along with the liberals, and then subsequently the Republicans get into power and they increase the number of seats on the court, and it's just a vicious cycle.
I think it goes beyond sour grapes. It's not just the fact that someone might disagree with a decision. It's the fact that in the last term, longstanding precedent has just been upended.
That's not what the president said, though, just to be clear.
No, the president said that the Supreme Court has turned into an advocacy group.
Yeah.
And, to Vin's point, that's just, he's a politician. That's partisan politics. He's feeding his base. But we're not politicians. And I feel like what is happening at the Supreme Court is more than just, oh, I didn't like that decision. It's a change in the whole institution, where precedent is doesn't matter. And that's why I asked the first question was, are we going to care about precedent in this term? Or are we just going to, is it just going to be a purely political, we have the votes, we're going to do whatever we want?
Probably the latter. Probably
I don't know
almost
why you would
certainly the latter. Other than the Chief Justice, purely the latter.
Yeah.
And we're going to, and don't forget on the other side, we're going to have the Democratic appointees. They're going to be dissenting all the time. The Republic is falling apart because they don't happen to like, what the majority is deciding. Now, look, can we just be real? These are close cases. In virtually all of these cases, it can be argued very legitimately for either side to win, right? One of the problems, which goes back to you have ideologues on both sides, everybody is so darn certain that their particular resolution is the correct one and the only correct one. I'm sorry, that's just not the case.
But close cases, isn't that the whole reason that a case ends up at the Supreme Court?
Thank you. And by close case, we mean there are good arguments on both sides. Good arguments.
Right. So what you're saying, are you really saying that the justices are so ideological at this point that they are rejecting out of hand the possibility of anything that might be legitimate on the other side? And if that's even the case, why are they bothering to hear oral arguments?
Well, that's exactly what Alito did. That's exactly what Alito did in the Dobbs case. In the Dobbs case, I mean, he absolutely dismissed the notion that there was some fundamental right to bodily autonomy, which is an ancient right, which is a right which has been recognized over and over and over again in American jurisprudence by courts all around the country. He dismissed it in one or two lines.
Yeah,
I mean, that's the basis.
I know that we're talking about the Supreme Court here, but what is interesting is that the subsequent fallout at lower courts across the nation, and not to mention voters, which of course we're not discussing here, like the Kansas decision, et cetera, but you have Arizona and Ohio, you've got lower court justices that are blocking all out bans. I mean, this is hardly a settled issue. If we end up with
no, it's not. You're absolutely right. This is not.
We're going to get back here again, and maybe. I mean, we have seen in the past. I don't know. Hope springs eternal, of course, but I don't really believe that this is possible. But you have seen in the past justices who were named to the court. It's a lifetime appointment. Expectation is that they're going to do one thing, and over time they change to do something else. So maybe some of these folks will temper their outlook. Maybe you will have a Gorsuch or, somebody become mellower with age.
And well, not only that, I mean, a decision like in Dobbs is a very, very narrow one. I'm sorry, liberals, and I'm one of them, but I'm sorry, but it's a very narrow decision. It is simply decisions, and I think it's totally wrong, but they're saying that there is no federal constitutional right of a woman to choose an abortion. That's it. They're not saying there can be no abortions. They're not saying that every single abortion restriction makes sense, is legitimate, is constitutional. There is little doubt in my mind that there will be other cases coming before the Supreme Court where a state has just gone way, way, way overboard and put restrictions on a woman's right to choose an abortion. And the Supreme Court, you're going to have the three liberals, and you're probably going to have the Chief Justice and Kavanaugh saying, well, these restrictions are just arbitrary. They're just not legitimate at all. There's just no government interest involved here.
But there's no case, at least in this term. So let's talk about some of the cases that we've got coming up. One that might fall into the realm of are you going to broaden this type of analysis is the 303 Creative case, a religious liberty and free expression case out of Colorado. Where there's a ban on discrimination based upon sexual orientation, and this kind of case has come up before, come up to the Supreme Court, where they said no, you can't discriminate based upon sexual orientation. It's been decided, and so how is this case now? How is this different? Why is it going back to the Supreme Court?
Well, it kind of has, but has not been decided. The Bake Shop case, right? Masterpiece Bake Shop case several years ago where you have the same Colorado civil rights law, which prohibits discrimination in public accommodations on the basis of sexual orientation. The baker complained on religious grounds, did not want to create a cake to celebrate a same-sex wedding. When the case got up to the United States Supreme Court, the Supreme Court reversed in favor of the baker, but at that time, writing the majority was Anthony Kennedy, who has always been in the vanguard of LGBTQ rights. And he said, we are not saying that businesses are allowed to discriminate on the basis of sexual orientation. What we are saying is that Colorado never gave the baker a fair hearing. Instead, at least the facts at the Supreme Court, they called him a Nazi. They said people like you are responsible for the Holocaust. So the Supreme Court sent the case back, right? There was a fair hearing. Colorado stuck to its guns, said you're not allowed to discriminate on the basis of sexual orientation, and the Supreme Court refused to hear the case again. But Ginsburg is gone. Anthony Kennedy is gone, right? These people are gone. What you have left is you still have Gorsuch, and you know what Gorsuch said in the bake shop case? Oh, this case is a nothing burger because the baker didn't even discriminate against the same-sex couple. The baker wouldn't create a same-sex cake for an opposite-sex couple or a same-sex couple. So he wasn't discriminating. Yeah, Liz is giving that look. Well, look, I didn't appoint Gorsuch.
That logic pattern, that is not even a lot. He did.
And I think he's the most, no, that was the argument that used to be used in favor of anti-miscegenation laws, that is to support the prohibitions against same-sex marriage. They would say there's no discrimination here. Everybody's got to marry within their same race.
David, but the fact pattern of this particular case is not the same.
It's not the same. No, it's not. I mean, it's similar though. The case is similar. They don't want to provide services.
You have the same public accommodations law prohibiting discrimination on the basis of sexual orientation. You got this website creator who does not want to create a website for a same-sex wedding and is claiming it's against my religion and also it's against my freedom of speech.
So, but
I don't want to express support.
But didn't we have a preview, a little sneak peek under the curtain here when we, again, I mean, I feel like we're going to be talking about Dobbs. It's going to get to be a little bit of a meme, if you will, a tiresome meme. But there is now the fear, because the door has been opened to the possibility that we're going to erode all sorts of things. We're going to erode privacy within the home when it comes to sexual behavior. We're going to erode rights for LGBTQ individuals when it comes to marriage. I mean, so this, if you believe that preview, then subsequently we can foresee that this case will be treated differently than the cake case.
Yeah, if the court is serious about what it argued in the Dobbs case, then this becomes an easy case because homosexual sodomy is nowhere mentioned in the Constitution. And homosexual sodomy in the history and tradition of this nation has been criminalized, right? So there you go. So there's freedom of speech and freedom of religion on one side, and there's no constitutional right on the other.
I should point out that the New York State Bar Association has filed an amicus in this case in support of the Colorado laws.
In support of the law, not
hopefully. Hopefully. Well, you got the three libs, so you know the way they're going to vote.
But the question is, where does Gorsuch go? Because he was the one who was like, well, that's not what we're saying here. And we're not actually talking about the erosion of every right. As getting back to the narrowness of the decision.
You're talking about Dobbs, right?
Yeah.
That was Kavanaugh, right?
Kavanaugh.
Kavanaugh, sorry,
was
not
saying
Gorsuch.
that it's only for this case. It's only because it involves an unborn child, and all other instances of precedent we will uphold. right?
Maybe.
We'll see.
And actually,
We'll see.
talking of Gorsuch in the Bostic case, where for the majority of the court, he construed the civil rights law of 1964, where sex discrimination was prohibited. He said sex discrimination necessarily includes sexual orientation discrimination. Remember, he did that. But he said, we are not talking about sexual orientation discrimination when it is a matter of religion. When it is a matter of religion. He is very, very much protective of free exercise of religion and religious objections, especially when it has to do with LGBTQ persons on the other side.
Well, we've got a number of very important cases that are
Yes.
coming up before the Supreme Court. Let's talk about, I know, the affirmative action cases.
This case, or rather,
Students for Fair
there's two
Admissions
of them.
versus
It's North Carolina
Harvard.
and Harvard.
Yes. Students
So
for Fair Admissions are the plaintiffs.
Right. So what's interesting about these, to me, is there's already discussion about the potential way to get around the expectation of the decision. So, race-based admissions is what's being challenged here. But in order to maximize diversification of college classes, which, by the way, I mean, we could have a whole other discussion about higher ed being in crisis and the enrollment numbers tanking. And certainly the affirmative action question is not going to help matters for people, but it's more of an affordability question.
But let's
However,
just give just what the case is about, right? So those schools look at the ethnicity of the person as part of the decision making in the admission process.
That's right.
And the argument is that should not be permitted. Not that they're required to do it, but that they can't do it even if they want to.
Yep.
Is what they're saying.
But I guess what they're saying, what colleges are saying now is, well, there's other ways to do that. You could do, for example, in other words, what I'm trying to say is, just like Dobbs, because you're seeing this issue now bubble up in different areas, this is not going to be a settled matter, because you'll see things like automatic enrollment, for example, of a certain percentage of every high schooler that's eligible across the country. The top tier would be automatically enrolled in a certain cadre of schools. That's one way to address diversity issues. And, some people may challenge that as well. So I just don't think that it's going to be a settled matter, regardless of how the court acts on these two particular cases.
Well, this is another case where, as recently as 2016 in University of Texas versus Fisher, it was held that such a standard for a college was permissible. So 6 years ago.
Well, this has been going on.
Or it doesn't look anything like what it looked like 6 years ago.
Yeah. And this has been going on since, the Bakke decision years and years ago, when Lewis Powell was on the court, and he wrote the concurring opinion saying you can't have a racial quota, but you could consider race with regard to all other kinds of factors. Then, Sandra Day O'Connor, when she became the centrist on the court, she said, well, diversity in education is a compelling interest. But then you had this series of University of Texas cases, and you had a change in the composition of the court. And they said, look, you got to apply strict scrutiny. So you have to say this is the only way that you can get diversity. Now, I think what's going to happen is that they're either going to apply strict scrutiny and do what Liz is suggesting, which is say you can't use race at all because there are other alternative ways to get what you want to get. But that is so incredibly dishonest. So you can have racial preferences, you can have reach out to racial minorities, but you just can't say you're doing it. You have to do that through other means where you don't say race. Instead, what you say is we take the top 10% of all the urban schools, right? Where you hope that you're going to get minority students. But this court, a majority of this court, including the Chief Justice, is saying the way to end racial discrimination is to end racial discrimination. They really are against affirmative action.
Well, We've got another case that has already been argued, the Merrill versus Milligan case, regarding Alabama's racial gerrymandering, right? So you've got almost the complete gutting of the Voting Rights Act. We've got in Alabama, more than 25% of the population is Black.
Yeah.
And in their gerrymandering, they've found they put one congressional district, 1 out of 7, where clearly under any math, even Vin's math, you would have at least 2. You'd have at least 2, right? So this case has been argued, right? There's almost nothing left of the Voting Rights Act if the court finds that this is acceptable.
Well, as with lots of things, it's even worse than that, David, because you had a 3-judge panel, federal district court panel, 3 judges. 2 of them were appointed by Trump. They took a look at what the Alabama Republican Party had done in redistricting, and they said it's pretty clear that this is racist gerrymandering. You're packing as many Black voters into one district, right, to give them that one district. And then you're spreading all the other Black voters all around, so their votes are totally diluted. The 3-judge district panel said, look, you can't use this gerrymandering. It looks, smells, tastes, feels like it's racist. The Republican Party appeals to the United States Supreme Court for an emergency order. And, in the shadow docket, which they don't have, the United States Supreme Court issues an emergency order overruling what the 3-judge district courts did and said, no. What the Alabama Republican Party did, that goes into effect. And if you want to complain about that, you got to come up to the court. Now the court has reversed. Instead of deciding whether or not what the Republican Party in Alabama did in their redistricting was racist, now what they're saying is, can race even be considered to ensure some fairness and equity? And that's Section 2 of the Voting Rights Act. Can it even be considered to make sure that Black voters are fairly represented in the redistricting? So, they changed it from the lower court saying this looks, smells, and tastes racist to, well, wait a minute, can you even fix it by considering race to make things fair? Terrible.
And of course, in that shadow docket decision, they said that this gerrymandering will stand for the time being, right?
That's
until there's a decision otherwise by the Supreme Court.
Yeah,
and now,
now
this is the time for the decision otherwise.
Right.
And so when you've got the Voting Rights Act, why would you not want to consider race when you're looking at application of the Voting Rights Act? When you're talking about intent in the legislature, this was the whole intent to stop this. And I think Justice Brown,
Jackson, the new Justice Jackson, yeah.
Right.
That's what she was saying. You want to be originalist, fine. You know what the original purpose of the Voting Rights Act was? To ameliorate all the problems, right, because of the discrimination against Blacks.
Could we just have an aside and say that the whole fact that we're still battling over redistricting at the state and federal levels writ large is kind of a pathetic commentary on the state of small d democracy? We still can't get this right. To say nothing of the Voting Rights Act, in New York State itself, we are battling in court over the appropriateness of various different gerrymandered legislative and congressional lines. The whole thing, and also to suggest, by the way, that a political process that draws lines, which is political inherently, that subsequently sets a political process in motion, should be apolitical is ridiculous.
Right.
But we were making progress. So Liz, the problem is that we were making progress. We had guidelines in place to try to make it fairer, to try to make it closer to one person, one vote, to try. And so it was not perfect, but we were moving towards the direction of making it better. Now we're not. Now we're moving in the opposite direction.
And
Well,
in
purely.
fact, there is
we don't know
another
that yet.
gerrymander.
We're assuming that the outcome of this case will be what we're expecting it to be.
Well,
Well-
I know which way we're moving, right?
Yeah,
We're not
okay,
moving
fair.
we're not moving towards perfection. This case, and, you know, Vin was saying, well, these are close cases. If you look at the appellate court decision, this wasn't a close case.
No, but
This
the
is not
appellate court
close.
was saying this was race-based. You were discriminating on the basis of race in creating this. But that doesn't even seem to be the issue that the Supreme Court wants to talk about. They want to talk about whether or not race can be used even for ameliorative purposes.
Yeah, I
even
love
for beneficent purposes.
I love the fact that the newest Supreme Court judge, Ketanji Brown Jackson, raised the issue
Yes.
of
Good for
you know,
her.
putting back on some of the other judges that say, oh, we got to look at the original intent. Of course, this was the intent. That's the whole purpose of this.
Right. Yeah.
Let's talk about there's another case I think Liz is alluding to, the Moore v. Harper
the Moore v.
case.
Harper, the North Carolina case.
Yeah, the North Carolina case about, and potentially could even have further reaching issues depending on how the case is decided, where they're saying that it's the state legislators that decide the federal elections, right?
Period.
Period. And this is a scary case.
Yeah. Liz, you want to talk about that?
No. This whole conversation makes me want to lie down. I can't, like, it's exhausting. I'm exhausted. by
Well,
this
I
whole
think I mean,
conversation.
I think you need to buck up a little bit. I think it's important that we talk about this case.
Yes.
I mean, it appears like boring when I'm saying, oh, independent state legislative doctrine. But what it's going to do is it's going to take the decision making out of the hands of the voters, out of the hands of the electoral college, and into the hands of the various state legislators to decide whatever they want, regardless of what the vote is. And we saw how important and significant that was in the 2020 election, that if this type of case takes hold and legislators can overturn what an electorate decides in a federal election, could be disastrous consequences, not only for the state, but for the country.
Yeah. So in North Carolina, where the voters are just about half and half, Democrat and Republican, what happens is the Republican legislature redistricted the states so that it would almost guarantee that there's going to be a disproportionate number of Republicans, right, being elected. So what happens is that the redistricting was challenged. It gets to the Supreme Court in the Rucho case a couple of years ago, and the Supreme Court says, what us worry, no standing. We don't know what the heck to do about this. There's no fair standard to apply. It goes back down to the North Carolina courts. The North Carolina courts, the appellate court, and then the Supreme Court said, no. This violates our state constitution. You may not be able to answer this, United States Supreme Court, but we in North Carolina can. And they said, the way this has been redistricted violates free speech, violates equal protection, violates rights of association. You've got to make it much more fair. Now, the Republicans didn't like that. So now they're challenging it again. And the basis for their challenge is this so-called independent state legislature doctrine. And in the independent state legislature,
which is in the Constitution, right?
Yes. Well, no, the Constitution doesn't say independent state legislature doctrine.
Right.
It says time, place, and manner shall be decided by the state legislature. It doesn't say, however, that you can violate free speech, equal protection, freedom of association, the right to vote by simply saying this is time, place, and manner. Okay. But there are a number of justices and some very conservative right-wing groups that want this independent state legislature doctrine, which would mean that a state Supreme Court cannot even say to the state legislature, by the way, you're the ones that decide the redistricting. But when you do that, you cannot violate this right. You can't violate that right. You can't violate whatever other rights.
I'm sorry.
The legislature, you get to do whatever you want, period, and nobody else gets to say anything.
Just to bring this home, just for a minute, as we are having this discussion, I believe there is a debate occurring on redistricting in a courtroom in Saratoga right now.
Yeah.
So the point of the matter is, like, a lot of this stuff, you know, I'm not the lawyer in the room, but a lot of this stuff, so I serve to sort of bring it down to the layman's level, or whatever that means, whatever level I can understand, which is fairly low. But the point of the matter is that if this seems to be sort of like highfalutin, you know, esoteric conversation, it is not.
It's not.
This is where the rubber hits the road in terms of your ability to be represented by the individuals that you choose at the voting booth.
You don't have to be a lawyer to understand this at all. In fact, you're probably better off understanding this if you're not a lawyer, because the lawyers oftentimes get all trapped in all this legalistic nonsense. The fact of the matter is that the legislatures around the country are redistricting their states in order to get a purely partisan advantage, not so that it's fair to the voter, but that the incumbents or the correct party in power, they get to ensure that they are going to be reelected, or they're going to be elected, even though the voters around the state, right, would choose a much different sort of redistricting. I mean, that's just basic fairness. You don't have to be a lawyer to understand that. You're absolutely right. I know it is exhausting, but you know, hey, this is what happens. This is what happens. You know,
I guess the real issue is, and we're always going to come back here, what is there to do about it? Like, I can't say, I'm sorry, what's occurring in Saratoga right now is a debate over absentee ballot reforms, not redistricting, but to me, they're sort of a piece of the same cloth, but not specifically about district lines. Anyway, because I checked myself just to be sure. We're always going to come back to the question of what is to be done about it.
Yeah.
Well, there's a couple.
Okay, go ahead, David, because I don't have an answer.
Yeah, well, number one is to be informed about what's going on, right? So, I think all three of us agree that we're talking about these esoteric, legalistic issues, but they have real everyday meaning, and it's not always clear. And so one of the things we can do is talk about it like we are. And I, hopefully get the word out so people understand what's going on. Then once you understand, make sure that you vote so that we have legislators that are not going to do something like this, that are not going to overturn what the electorate has decided. Those are
so the case doesn't get to the court at the first place, because by the time it gets to the court, we're sunk. In
some instances, we are. If it gets to the Supreme Court, potentially, yes.
Court of its current makeup.
The current Supreme Court, yes.
Right, but
can we talk about something lighter, like animal rights?
Well, the animal rights case is also depressing, but I know we like to talk about animals. There's a case of National Pork Producers Council versus Ross, and it's about keeping pigs happy and healthy. It invokes the Commerce Clause, where California has said if you're going to sell pork in our state, you've got to have the pig has to grow up in a cage that's at least 24 square feet.
Right.
And the pork producers said, California shouldn't be telling us what to do. We're growing our pigs in Iowa or Nebraska or anywhere else. And so you violated the Commerce Clause. And because California is now imposing its laws on pork producers in other states.
I do have to say that this is not, and again, it's interesting that California has this one. We've got one not similar, and it's not at the Supreme Court, but there was a foie gras ban. Now, you may or may not know about foie gras, but it requires the force feeding of geese, which is, many people believe is inhumane. And then subsequently their liver gets very fatty, and it's a delicacy.
The people or the geese?
The geese. The point.
I didn't know there's a foie gras ban in New York?
There's a foie gras ban. Well, there
Foie
was
gras.
in New York, but it's not in New York City. But it won't go into effect on November 25th as it was supposed to, because a lawsuit brought by 2 Hudson Valley farmers is winding its way through the legal system, and a preliminary injunction on enforcing the law by the city is in place. And what do the farms cite? Economic hardship, which is exactly what we're seeing in the pork production case.
Is the law against the force feeding or any?
The law is not, it's not a law that bans the production of foie gras. It's a law that bans the sale, if I'm not mistaken, in New York City.
Yeah,
Any
well,
sale,
of course.
even if it's from a duck that's just eating.
No duck,
casually.
No duck voluntarily. I know somebody will catch me on this. There is a farmer somewhere who believes or who says that he has gotten to a point where he can convince the geese and ducks to force feed themselves, like they eat themselves to the point where, but they need to overeat in a serious way in order for their liver to become as fatty as is required for a foie gras. But the point of the matter is, this is not sort of some like, oh, this is weird. It's a weird California thing. It is not. And there's a whole host of research that indicates that humane treatment of animals actually ends up with a better product for humans in terms of the quality of the meat. So even if you're a meat eater, you should care about this. And also if you care about animal rights and, you should care about this.
I mean, just being decent human beings to other members of the animal kingdom that are intelligent and really much more similar than dissimilar to us.
So
come on, have a little St. Francis.
Animals on the planet, by the way.
Yeah, absolutely. But
is the fact that California is saying we're not going to allow this to be sold in our state, is that violating the Commerce Clause?
Well, that's such an interesting thing, and it does get into legalistics, but I'll try to make it in such a way that even Liz will find it interesting.
That's kind. Thank you.
Okay, even Liz will find it interesting. Okay, now, what I will love about this is that the so-called states' rights justices, the ones that, leave it up to the states, they're probably going to be the ones that are going to vote against California and the hell with states' rights. With regard to the Commerce Clause in the Constitution gives Congress the right to regulate commerce among the states, okay? Nothing in the Constitution literally prohibits the states from having regulations or laws that might inhibit interstate commerce. There's absolutely nothing in there. The Supreme Court came up with this, and they called it the Dormant Commerce Clause. Dormant Commerce Clause meaning it really ain't there. We just made it up, right?
Oh,
but
wait,
that prohibits
the
states.
Case actually is not just impacting California. It would impact
no, of course,
in the entire nation.
It is going to impact it, but there isn't any law coming out of Congress saying that California can't do this, because if Congress said that, if Congress says this interferes too much with interstate commerce, we're not allowing it, Congress is allowed to do that under its Commerce Clause power. There is nothing right now, either literally in the Constitution or in federal law, that prohibits California from doing this. So what the court's going to have to say is that California, by doing this, you're interfering too much with interstate commerce. And even though the Constitution itself doesn't really prohibit you from doing that, we're going to tell you under this doctrine that we made up, the Dormant Commerce Clause, you're not allowed to do it.
Can I just note, by the way, which is so fascinating in the oral arguments which came up here, if they felt like banning all pork products, they could do that legally in California. They could say, you know what? Screw you. You don't want to adhere to our rules in terms of what we consider to be humanely raised pork. Yeah. You can't, no pork for you anywhere in California. Problem is that Californians buy about 13% of the pork, period, that's sold in America. And that would be a significant problem. So you would.
Well, that's actually a very good argument on behalf of California. California could actually ban pork completely. Yeah. Right? Since we could ban it completely, aren't we allowed to at least put some restrictions
Well, that's what they're
on it?
saying, right?
Yeah.
So that's what they're saying. No one is saying that a ban would be constitutional. So why can you altogether ban a product and effectively say farmers who are outside of our state are deprived of
That's
the
right.
market
Yeah,
in our
yeah.
state, but we can't enact a less strict regulation that permits you to sell your product just within some parameters that we're setting for you. Like, for example, we don't allow DDT to be used in the pesticides
Right,
on our
right.
apples or what have you.
Right. And California is doing this for humane reasons. It's not doing this for protectionist reasons, right? It's not like saying, this is what California pig growers do, so we're going to make everybody else do that. So that really, that's going to protect.
No, but Justice
California.
Kagan, it's interesting that you say that, because the liberal justices raise the possibility of a slippery slope, which is that you establish a precedent, which of course we know that this court doesn't adhere to anyway, so maybe we shouldn't be worried about it, but such that you could say, well, we also are going to ban products that are not made by unions, for example, right? Non-union labor, whatever it is that you decide to put all these parameters on, could be a problem if we go down this road, right? Or if you say, which is another problem that we've had, but this is not similar, not necessarily an apples to apples comparison, or pigs to pigs, as we're having this discussion about pigs, but the idea that, well, we don't like your labor practices, or we don't like your hiring practices, or we don't like your diversity or lack thereof of your company, and so therefore you can't sell your products within our state.
Yeah. And slippery slope, virtually all these cases are about matters of degree. They're virtually all matters. That's what judges get paid for crying out loud. Exercise whatever wisdom you have and judgment ability you have to come up with a resolution that makes some sense, so
we've discussed, there's a lot of important cases this term in the Supreme Court. As I think you both noted, some of them are depressing us a little bit, and the potential outcomes.
Name one that's uplifting you, David. I'll wait.
All right. Well, you can wait. There is one that's uplifting me. There's a parody case, Novak versus City of Parody, City of Parma, and someone wrote something on Facebook that was intended to be a parody. It was banned.
Oh, it is a parody.
It's gone up to the Supreme Court, and I tell you this: the Onion newspaper filed an amicus,
which was a parody.
That is crazy. That's like art. What is it? What's it? Art creating what art imitating life imitating art.
And you should read it. And you should read it. And you should
read it.
Be reminded why we need parody, because sometimes things are so unreal in life that you need parody just to shed some light on how crazy some things are. So there you go. Of course, Novak v. Parma.
Yeah, the United States Supreme Court has protected parody previously as being a First Amendment right. Remember the one with Jerry Falwell supposedly having sex with his mother? But of course, what they said was,
why do you always have to bring that one up? Why is that? Why is that the one you always have to go to? Why do you always have to? You don't have to keep bringing it up, though.
Poor Jerry Falwell.
I think it's the first time I ever mentioned it on this show.
I can't recall him ever mentioning it either.
Every time. But we're gonna do a montage.
The Supreme Court, speaking through William Rehnquist, said, look, parody has been part of American political expression from the beginning. And number two, every reasonable person knew this was a parody. Right? And I think that's what the issue is in this case that's before the court now. Was it clear? Would reasonable people know it's a parody? Or was there actually some intention, or they didn't care whether or not people took it seriously? I think those are going to be issues.
Vin, to be clear, increasingly, things that the Onion wrote in the not too distant past that we all thought were parody turned out to be true. And also the War of the Worlds was not a parody, but a joke, or whatever you would call it, a spoof. It seems too lighthearted, but the point is people thought it was real. People also thought that the story about spaghetti growing on trees is real. So, how is it that you can legislate or make a decision, a judicial decision, a reasonable decision about the reasonable person understanding parody and being able to determine truth from fiction when truth and fiction are so
well? The Onion actually in their brief talks about that, because there was some discussion as to whether if it's a parody, it should be labeled as a parody. And the Onion says that takes it away. That takes the joke away. The whole point is that you look at it, you think it might be real, and then you realize the joke's on you because it's not. And if you have to make it obvious that it's a parody, then it no longer has the same effect.
This is like warnings. The coffee that you are about to consume is going to be hot. Please don't put it on your lap as you drive 90 miles an hour or what have you.
It's exactly like that.
No,
parody
what
is
David
like hot
said
coffee.
is absolutely true. The reasonable person, even if the reasonable person at first blush says, boy, this might be true, then very shortly thereafter says, oh, well, of course, this is parody. Yeah, I think that
the question, now we have to have a whole show about the reasonable person standard, because that's been a shifting target for some time.
Maybe we should do a parody show. The whole show just be
a parody. Whole show is parody.
A parody of Miranda Warnings.
No, this was pretty good, Liz. Don't be downplaying this roundtable. I think we cover some really good stuff.
A lot of good stuff.
Yeah, the pig loving audience is going to be upset, though. They're going to rise up.
Why are they going to be upset? I'm for California in this one.
Okay.
I was also for Rowan Wilson's dissent in the
freedom of geese to make decisions about how slender or fat they should be.
And I consider myself a friend of pigs.
David Miranda, friend of pigs, Esquire.
Pigs are smarter than lots of people I know.
Yes. P.S. There's data that shows that a pig actually is as smart or smarter than your average human 3-year-old.
There you go.
We were talking about the Happy the Elephant case in the past. Pigs. Who's smarter, pigs or elephants?
Oh, this is hard.
We'll have to, maybe we'll save that one for another day.
Yeah.
We'll have the pig v. elephant.
That's a good.
The intelligence of pigs comparable to elephants and dolphins. In a study conducted at the University of Cambridge, it was found that pigs are intelligent beings capable of recognizing themselves in a mirror and can quickly learn objects that were shown in the reflections.
Wow.
Yeah. All right. Pigs.
Pigs can also be potty trained.
One for
Not
pigs.
so sure about elephants.
Or dolphins.
That's a good place to leave it right there.
That's perfect. Liz and Vin, thank you for the SCOTUS preview on Miranda Warnings. Thank you both very much.
This was enlightening and fun.
This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.